appellate practice. He's attained an AV preeminent rating, the highest rating possible. Jamie has been selected on numerous occasions to present as a speaker for the DOL and frequently provides workers' comp and liability training to his clients. Lauren is a partner in Sanders and Williams and has been an insurance defense litigator for over a decade. I got you really beat as as a litigator. Lauren represents employers, insurers, and third-party administrators all over the state of Alabama. Lauren has a particular interest in workers' comp defense, trucking litigation, products and premises liability, and construction defect matters. She has successfully tried many cases to conclusion and has also been a speaker many times in workers' comp issues and for the DOL. Are you ready?
We are. Thank you, Davita. Thank you so much. Yes, I'm Jamie Sanders and Lauren Farrington of Sanders and Williams. Thanks for being here today, as if you had a choice.
Probably not.
But anyway. Hey, listen, I almost wasn't here this morning either. I was literally, I got up this morning and I had no water. So I'm calling my partners and saying, hey, can I come to your house? He doesn't answer his phone. I call Lauren and I was like, hey, can I come to your hotel room? I'd get a shower. She doesn't answer. So I'm like, well, I guess I'm gonna put on a daggum golf hat and go look like a homeless person. But anyway, it worked out all at the end. All of a sudden, we had water. I don't know.
Well, you look great. You smell good.
Thank you. Thank you. Thank you. I always need affirmation. Thanks. All right. So we're going to talk about, as Davita said, jurisdictional issues, both state and interstate, and conflicts that occur. It is extremely important. It is also like watching paint dry, so bear with us. But it is so relevant because we all are dealing with it in one way or another almost every day and almost every case. Some are plain and dry and you know exactly where you are and you're going to settle it and it's fine, but a lot of them run into these conflicts. So we're gonna talk about the jurisdictions within the state of Alabama, venues, what venue are you in, when to change a venue, and then perhaps when to file a lawsuit first. And then we're also going to talk about concurrent jurisdictions, state to state. You've got companies that are in multiple states, employees in multiple states. They're contracted sometimes they're not contracted, sometimes they're jurisdictional agreements. So what do we do? And then we're going to also look a little bit at trying to have a little cost containment. So with that, I am going to let Lauren start us out with jurisdiction within Alabama.
Yeah, thank you. And good to see everybody. Hope y'all are doing well. I did just have one question. Oh, wait, here we go. Okay, it's working now. I couldn't get our PowerPoint. Okay. All right. So like Jamie said, we're going to start with jurisdiction within Alabama, and kind of the main takeaway I want you guys to get out of this is that we are a judicial state. Our work comp cases are heard before the circuit court judges. A lot of other states, they have ALJs, but here in Alabama, we are in circuit court. So that means that the judges who hear work comp cases are the same judges that are hearing criminal cases, divorce cases, malpractice cases, products, everything. So this has its advantages and disadvantages. Some of the advantages are that we can potentially change venues if we don't like the one we're in, because work comp cases can be heard where the injury occurred or where the claimant resides. So there can often be times when there's more than one proper venue. So it's kind of an advantage to being in the circuit court system. But a disadvantage is that our judges are very busy, have lots of different cases, and sometimes they might not know a lot about work comp. Whereas if you're with an ALJ, that's all they do. So a lot of times us as attorneys, we're having to kind of educate the judges doing a lot of briefs and filings to get them up to speed. Some may also tend to be more pro plaintiff. So those are just some considerations we factor in. The makeup in Alabama, so we've got a state map here. These are all of the counties. Alabama has 67 counties that are divided into 41 judicial circuits. So some of the smaller counties are combined into one. And then our largest one here in Jefferson County actually has 2 divisions. We have a Birmingham division and we have a Bessemer division. So you may be wondering which ones are better. Well, roughly speaking, the northern part of the state tends to be pretty conservative. Places like Birmingham, Huntsville, Florence, Decatur, they're all pretty conservative. Montgomery and Mobile kind of in the southern half there. They're also conservative, may not be quite as conservative as the northern half, but also fairly conservative. The most liberal venues we find are the smaller, less populated ones, especially the ones that run from east to west in the middle of the state. And one I always find myself in, we have a lot of cases there, Etowah County. It's not always the best. We've done a lot of motions to transfer out of there when we can. So that is the just kind of a brief overview of the jurisdiction within Alabama. We're going to move on to when you can file a lawsuit and kind of talk about where and how that process works. Jamie's going to start us off with that.
Yeah, and this will blend into quite a bit, probably the largest portion of what we talk about today, because it includes it all really, with the exception of from state to state. So when to file. So Alabama's code 25581 allows either the employee or the employer to file a lawsuit. While we are not in the business, quote, business of filing lawsuits, there are times that we need to strongly consider, if not strongly consider, just do it and be the aggressor in the case and file the lawsuit. And we're going to talk about some of those situations. One may well be venue. And we find this not to be uncommon. So you're in, let's see, go back to the state. Let's say you're in, if you got a, is that got a thingy?
Flasher. Yeah, it does.
Oh, well, I'm gonna have to get down here, I guess. So let's just assume, and I'll give you, for instance, a case that really kind of legislates this whole issue. And it was a case that was, it had a claimant who is from Walker County, Jasper, Alabama. Okay, it's contiguous with Jefferson County. There's Jefferson, there's Walker, and we're in Jefferson right now. So for those that aren't here, so the claimant's from Walker. There's a fund that is located in Birmingham, and the fund has its client and employer in Coleman. So there we go. We got 3 counties. Boom, boom, boom. You're like, and as Lauren just said, North Alabama is relatively conservative, and not so fast. We got to know where we are. We got to know which county. We got to know which judge, and that's very, very important. You should call your lawyer every time you have a case, literally. Unless you just know it's going to settle. But if you think there's anything in there, just call them and just say, hey, what does this look like? Because that makes all the difference in the world. So this case, they wanted the fund got pretty slick. They knew Walker County was a really, really bad county, and that you can have great facts, wonderful facts. You denied it. You should have denied it. You denied every time. And you go to Walker County and your lawyer has to go try the case, and they come back with a PT, and you go, God, aren't you good? I mean, who the hell are you? But the problem is they're in a bad venue, and it doesn't matter who you are. And it doesn't matter if it's F. Lee Bailey or whomever. So be careful about that. So here's what they did. They file it in Coleman where the employer is. Okay, because Coleman is completely different. You have good facts, you're going to get a good result. Just almost can guarantee it. In Walker County, no. So what happens is a case that could be PT one, because you filed it first in Coleman County and plaintiff's lawyer now is going, well, there goes that case. Why don't we settle? All right. So that may do that. It may prompt a quick, cheap, inexpensive settlement. All right. At the very least, you're now in a safe place and you've got something to work with. So that's just a good example of why you want to think about that. You want to ask your lawyer, where are we? What are the chances? What does it look like? Now let's talk about one where same kind of situation. We've got a matter right now where a person hurt, the employee hurt her left knee and then went, and it was compensable. So we paid for it. Left her employment, went somewhere else. While she's at the other employment, she starts having right knee issues. Her right knee then needs to have surgery. Not our baby, no problem here as far as we're concerned. But as she is having problems with her gait in her right leg, here goes her left knee again, and they're back at us. Okay, now they filed on this left knee saying, meds open in Alabama. All my life, I got a knee problem, left knee, I need it. We want to file a lawsuit first. We've asked our client to do that. And here's why, because the new doctor in his doctor's notes say that the whole time he's treating her now is right knee, not the first complaint of a left knee. Not one. Okay, new employer. So now we want to get to this doctor first. I want this deposition. I don't want plaintiff to file a lawsuit. We're denying it. I don't want plaintiff's lawyer to file a lawsuit and have first bite at the apple of the doctor and be able to slant his line of questionings or hers to the doctor such that he could get a favorable response to, well, could this have? Possibly could it have had some problem leading up to the right knee and it be compensable? Versus, if I'm taking a deposition, doctor, all of your notes, you treated her for the right knee. Is that correct? Yes. Was there ever a mention of a left knee? No. Would you have expected to, if there was an issue with the left knee, for there to be a complaint? Yes. And if there was a complaint, would you not have put it in your history and documented that? He goes, absolutely. So in your opinion, was the right knee the exacerbating factor of the left knee? Yes, didn't get a complaint from it before. Now I've got that complaint. I should have this case now, unless I'm in Walker County. No, but I should have this case now. Now we're in good shape. So that's why you want to do these things. You want to do it sometimes to control the claim. Now that's a double-edged sword because you can also lose control if you file the lawsuit. And what do I mean by that? Let's say we've denied it right off the bat. Whatever our facts are very favorable to us. If we file it, we know we're going to file it in a good jurisdiction. So that's good. And that probably puts us in a good light. But what might we lose? We might lose medical control because we're not going to pay for it, right? Let's just assume this is a case where we're not going to pay for medical. Now they go out and get their own medical, and that can be a little tricky. But again, and I wouldn't do it, by the way, and I would ask my lawyer if they wanted to do that. Are you sure we're in a good jurisdiction so that that judge is going to be conscientious of what's going on, why we denied it? We had good grounds, and the fact that she's now going to a new doctor, their own doctor, which probably could get them a favorable result in terms of their opinion, but still from a legal standpoint, we're in good shape. So be sure about that when you do that. That's kind of a little tricky thing. Again, it can force an employee to get a lawyer if we file first. Really? I mean, how many difficult employees do we have, and or even worse, a family member of the employee. Those are the worst, whatever it's, the husband got hurt and there's a really strong woman in the family and the wife tells him everything to do. And they're on the phone, you can hear them in the background. They're singing and you're going, oh God. And or they grab the daggum phone out of their hand and go, you pay, so there you go. That may force them to get a lawyer. Now you've got somebody to actually negotiate your case that's reasonable, you hope. Most do. Most chances you got a better shot on that one. So just, the last one was a negotiable settlement, same thing, same exact situation. But those are some good examples of why you want to go ahead and start thinking that way. Be a little aggressive sometimes. Oh, how about old dogs? How many people have old dogs that are 20 and 30 years old and meds are open for life, and all of a sudden they've started treating for something that they say is somewhat related to the knee. My heart's bad now, and it was all because I couldn't get exercise because my knee was bad, and I got this and and they have a doctor say, yeah. Well, I don't know what the situation is. As we all know, it could be anything. But you may want to do it on an old dog because you are not wanting to pay for every medical condition that this person now says they have as a result of their own job injury. So you file a lawsuit and start the process. I'm going to turn this over now as I have yapped for a while.
Yeah.
Lauren's like, I thought I was doing this with you.
Okay, this clicker back so we can clicker.
Let's
go to the next slide. All right, guys. Okay, sorry about the formatting there. I don't know what happened. All right, so if you find yourself in one of these unfavorable venues that we've been talking about, there are some avenues to potentially change it. And we do this by filing what's called a motion to transfer. So again, work comp cases in Alabama can be heard where the claimant resides, if the employer does business there, or where the accident occurred. So again, if these are two different places, we might be able to switch venues. There's two grounds that we argue in our motion to transfer, forum non-convenes and interest of justice. Forum non-convenes basically means it's more convenient for the lawsuit, for the parties and the witnesses to have the lawsuit heard in whatever venue you're trying to change it to. So if the claimant and the witnesses and the employer, they're all in Huntsville, but the claimant just happens, maybe he's driving or whatever, he's in Mobile, gets hurt and wants to file in Mobile. Well, it would be more convenient. That would be the argument. Forum non-convenes. It's more convenient if we just have it heard in Huntsville. Interest of justice is means that you don't want to waste a court's time with a case that they have little to no connection with that county. So you don't want to waste the court's resources, time, all of that when this case has no relevance there. I have one now where the injured worker, he filed suit in Macon County, which is one of those ones I was talking about, kind of in the middle, east to west, very small, not typically a great venue for defendants. And so when I got the case, I knew he lived in Chilton County, which is much better for defendants. So I was trying to figure out if we could potentially transfer this. And so as I started digging in, I noticed that there was no connection to Macon County at all. The employer did not do any business there other than, this guy was a truck driver. So other than just driving through on his routes, they didn't have any offices in Macon County. He wasn't supposed to stop in Macon County. Well, he could, and how the accident occurred is he's getting off the highway on an exit ramp to go to a truck stop and use the bathroom, and he wrecks his truck. Getting off the ramp, but other than just driving through, no connection to Macon County. He didn't treat in Macon County. He treated primarily in Montgomery County, which is closer. It's kind of halfway between Macon and Chilton, but a lot of the doctors were closer to Chilton. My client, the truck company, is a Tennessee corporation, and if they would have to come down to court, they were closer to Chilton. And then he obviously lived in Chilton. So I argued both the forum non-convenes and the interest of justice. That it should be transferred from Macon to Chilton, and the judge granted it. So now we're pending in Chilton. So the burden is on the moving party. So I had the burden of proof to show why it needed to be transferred. And then the judge that you're trying to transfer it from is the one who grants it or won't grant it. So that was the Macon County judge. So That one worked out in our favor, and we're now in a much, much better venue for our client.
Along those same lines, another matter where we get a complaint. Who in here has not had a case with Steve Ford? That's what I figured. Everybody has had one with Steve Ford. Okay. Steve's a very good lawyer, by the way, you guys. He's very, very busy. He's got a lot of cases and he knows what he's doing and he knows how to do it appellate wise and otherwise. But he filed his lawsuit in Sumter County. Sumter is, well, anyway, it's west of here, a little bit southwest of here. It's not a good venue for employers. And in the complaint, it was a truck wreck. And in the complaint, the plaintiff claimed injuries, just a few, to the head, neck, shoulder, arm, back, leg, and psychological issues. So we felt really good about this, and that it was in a bad venue and that we were going to get PT. I mean, come on, that's probably where this thing is headed if we can't get it out of Sumter County. The accident occurred in Escambia County, which is on the southern part of Alabama. And as Lauren was just saying, one of the factors is interest of justice. So interest of justice follows where the event occurred, where the accident occurred. And the reason our courts say and what they reason is that if it occurred in your county, you as a citizen of that county has more interest in the outcome and the bearing of that case than somebody across the state that doesn't, have any affiliation with that area. So that's the strongest reason, is where does it happen? And then what comes in with that is the forum non-convenes, what's convenient for all the parties, that kind of thing. We were also successful getting this moved to Escambia County. What happened with that case? We settled it. And we settled it for a really, really reasonable number, even though it was head, neck, shoulder, arm, back, leg, psych. And by the way, all of those were treated. Those were all treated, in the medical records, and also they were compensable injuries, but the difference in the venue made that much difference. And that's why we have to be really cognizant of that. The next thing we're going to start talking about, we don't have much time. You all are fortunate that we only had 30 minutes to talk about this subject instead of 45. Concurrent jurisdiction. So what happens between states? How many of us have trucking and construction and there's a list where the company is all over the place and the employees are all over the place and have to move around, i.e. they're over the road truckers or they're contractors and construction workers that have to go from site to site. And what rules? Which issue is the defining element that keeps you in a particular state? They vary, obviously. For instance, like meds open or close. I mean, meds in Alabama are a lifetime. Every state, I think, that touches our state has a different variation of how they control medical. So it's very different. Employers in multi-state operations should always consider individual statutes. What are the statutes of the states? Again, this is, I think, a really good area where you call your counsel and you say, is there anything we can do with this thing? All right, you can have contracts for hire. Does that necessarily define where it's going to be? No, it doesn't. There are exceptions, just like everything in law. Don't you love the word in general? Well, so we always have these loopholes. We always have these exceptions. Generally, it's where the employer is located but then there are exceptions to that. So we're going to get into a few of those. One of the things that as a claims person, TPA, insurance writer is, you know, you can have jurisdictional agreements. And we've done this for clients. And a jurisdictional agreement will define where a lawsuit is going to be held. And all that is saying, in the event that you get injured, you will succumb to this state, whatever state that is, and it's signed off by both parties. And so it's a waiver, so to speak, by that employee to that jurisdiction. Contracts for hire are not necessarily that strong. Well, they're not that strong because there are exceptions. So I'm going to turn this back over to Lauren, and she's probably going to conclude this in concurrent jurisdictions.
Yeah, so I'm going to end with talking about section 25.5.
35.
35. Okay, hang on. There we go. There we go. So 25.535 implies that all in-state injuries are going to be covered under the Alabama work comp. But there are a few circumstances where an employee who's injured outside of the state of Alabama can still bring their claim in the state of Alabama. They're listed here. I'll quickly go through them. We have a case, an exemplar case for each one, but unfortunately, I don't think we're going to get to go through that with you. So if you have any questions after I just briefly tell you what they are, feel free to reach out to your counsel. Feel free to reach out to us if you think any of these situations may apply with one of your cases. But the first one is when employment is principally localized in Alabama, and the courts have kind of defined principally localized as where does the employee spend a substantial amount of their time? Are they spending 90% of their time in Alabama? If so, it's going to be principally localized here. But if they're spending 10% in Alabama, 10% in Missouri, 10% in California, 10% in another state, the courts are going to say they're not principally localized anywhere. So number two, it kind of goes into that when an injured worker is working under a contract of hire made in Alabama. So when they're hired in Alabama and their employment is not principally localized in any state, they can still bring their claim in Alabama. The third exception is when the injured worker is working under a contract of hire made in Alabama and his employment was principally localized in a state whose work comp laws are not applicable to his employer, then they can still bring it in Alabama. And the last one is when an injured worker is hired in Alabama, working under a contract of hire in Alabama for employment outside of the US. So say somebody gets a phone, the case I was going to tell you guys about is the worker got a phone call in his home here in Alabama to go work in Antigua. He goes to Antigua, he's working on a ship, gets injured. Well, comes back to Alabama and he brings his claim in Alabama. So that's that one.
Probably a case that y'all deal with every day. Go to Antigua, right?
Yeah, sure. Y'all have a lot of those. Well, I think that's all the time we have. We appreciate y'all listening and not falling asleep. I know it's not the most interesting topic, but I hope that you guys learned something. And if you have any follow-up questions, please feel free to reach out to Jamie or myself, our other law partner, Matt. We're all here, happy to answer any questions. So
Thank you. Our next discussion is navigating the maze workplace violence claims. This is going to be presented by Trey Dowdy, partner Swift Curry. His education was at the BA at the University of Virginia, MSS at the U.S. Army War College, and his law degree at Cumberland School of Law at Samford University.